The claim filed by policyholders from Grenada and Antigua and Barbuda was filed under the court's original jurisdiction, which handles disputes arising from the revised Treaty of Chaguaramas. Chief Justice Adrian Saunders announced the judgment on Tuesday.
The court found that it could not have been within the contemplation of the framers of the RTC that the member states in such circumstances would be obliged to compensate all BAICO policyholders in all CARICOM states for all their loss and damage. The court accepted that this is an objective and reasonable justification for the alleged difference in treatment of the companies. The court considered there was no obligation to extend any relief to institutions outside of the defendant member state, and therefore no right in the claimants to obtain the relief they sought. The claim was dismissed, and the parties were ordered to bear their own costs.
The case involved allegations that Trinidad and Tobago's bailout of subsidiaries of CL Financial Limited, CLF, BAICO's parent company, discriminated against policyholders outside Trinidad and Tobago. Following CLF's collapse in 2009, the Trinidad and Tobago government intervened to support its locally registered subsidiaries, including Colonial Life Insurance Company, CLICO, and BAICO's Trinidad operations, but did not extend relief to policyholders in other CARICOM member states. The court concluded that the government's actions in bailing out CLF and its subsidiaries were consistent with the exceptions outlined in Article 32 of the revised Treaty of Chaguaramas. It found that these measures fell within the state's governmental authority and were aimed at alleviating the economic fallout from CLF's collapse. The policyholders alleged that the Trinidad and Tobago government violated several articles of the revised treaty, specifically Articles 36, 37, 38, and 184, which pertain to discrimination and consumer protection. However, the court determined that these claims were unfounded, as the government's actions did not contravene the treaty's provisions on competition policy and consumer protection. The court ruled that the claimants failed to demonstrate they were treated less favorably than similarly situated individuals, or that any alleged discrimination was based solely on nationality, as required by Article 7 of the treaty. In conclusion, the CCJ dismissed the claim, with each party responsible for its own costs. Chief Justice Saunders noted that the judgment is final and the copies will be made available to the involved parties. Reporting for GBN News, Beverly Tellisford.